Everyone keeps arguing about whether this shooting was justified, but that's not the hardest question. The harder question is this: even if it was not justified, will any prosecutor ever take this case into a criminal courtroom? Because wrong and chargeable are not the same thing. This is Crime News Cross-Examined, where we take real crime stories and test them against the legal system that actually decides what happens next. Now the facts. The Pretti shooting happens in public, in daylight, and it immediately divides the people. On Monday, I gave my opinion on self-defense, and I said I did not think it was justified. Today is not a walk back. Today is a different question. Not was it wrong, but what will prosecutors realistically do with it? Now the prosecution's case. Let me start with my opinion, clearly stated. I do not think the Attorney General will bring federal criminal charges in this case. That conclusion is less about abstract legal theory and more about institutional reality. Federal charging decisions in cases involving federal officers are driven first by institutional risk and only secondarily by politics. DOJ looks at jury burden, the requirement to prove everything beyond a reasonable doubt, national precedent, and the long-term consequences of criminally prosecuting its own officers, even where probable cause exists. That's the reality of federal prosecution. People also, though, ask whether a future administration could bring charges later, since the statute of limitations would not have run. Legally, that's true. A future administration could theoretically charge, but practically, it's very unlikely. Once DOJ completes a use of force review involving federal officers and declines charges, later administrations almost never reverse that decision, absent new evidence. The legal possibility exists. Institutional practice makes it rare. At the state level, the prosecution's theory would be much simpler. State prosecutors would argue that no imminent threat of death or serious bodily harm existed at the moment deadly force was used, and that whatever danger existed earlier had ceased to exist. Against a civilian, that often gets you to trial. But this case does not stay there. Now the defense case. In my view, there would be no defense of federal criminal charges because I don't expect those charges even to be filed. The real defense begins only if state charges are brought. The first move would not be a jury trial. It would be removal. Federal officers prosecuted for conduct connected to official duties can remove the case to federal court. Once there, the defense would invoke Supremacy Clause immunity. This is not an argument that the shooting was justified. It is an argument about constitutional limits. The Constitution bars states from prosecuting federal officers for actions taken while carrying out federal duties, so long as the officer arguably acted within the scope of those duties and arguably believed the conduct was necessary. That word, arguably, matters. Now the cross-examination. This is where people think a judge is secretly holding a mini-trial. That's not what's happening. The judge is not deciding whether deadly force was actually necessary, not weighing credibility, not choosing whose version of events is right. The judge is asking a threshold question. Is this the kind of case the state court is even allowed to try at all? This isn't a referee reviewing the play. It's a bouncer deciding whether the game can even be played in this building. Here's the legal standard. The judge looks at whether the officer was acting under federal authority and whether the conduct was so clearly outside that authority or so clearly unnecessary that no reasonable connection to federal duties can even be argued at the threshold stage. And here's what that does not mean. If a federal agent leaves duty, goes home, and commits a personal crime, that is clearly outside federal authority. No removal, no immunity. This case is different. So the question is not, was deadly force actually necessary? It is, was it clearly outside federal authority or clearly unnecessary with no plausible connection to federal duties? If the answer isn't clearly yes, ambiguity favors dismissal. And now my ruling, and there's no contradiction. On Monday, I gave a merits opinion on justification. Today is about jurisdiction and constitutional limits. Applying the actual legal standard, not a jury standard, not hindsight, and not public outrage. I do not expect federal criminal charges. even under a future administration. Yes, I think state charges are possible, but if they are filed, I expect removal to federal court and a Supremacy Clause motion to dismiss. Applying that standard, I believe a federal judge would dismiss, not because the shooting was justified, but because the conduct would likely be viewed as arguably connected to federal duties and arguably believed to be necessary, even if mistaken. That dismissal would not be an endorsement. It would be a constitutional boundary. The Constitution intentionally draws that line before we ever reach a jury, not after. Wrong doesn't always equal chargeable. If you want clear legal rulings on the cases everyone is arguing about, you're in the right place. I'll see you on the next one.